right, welcome students, teachers, and anybody else interested in the American Constitution. This is the 4Bs again, coming to you, not so live, but recorded from all over America, almost the four corners there. And tonight we are honored to have not only a true intellectual, but a good friend of ours. And that is Professor Henry Chambers. He is from the University of Richmond Law. He is the Austin E. Owen Research Scholar and Professor of Law. So what's a research scholar? You spend most of your time researching?
No, it's just a really good name to give us, you know, in lieu of money, which I'm okay with. I'll take a title instead of money, but that's really what it's all about. And that's good. That's good.
And he's got a number of areas of expertise. Amongst those are voting rights, criminal law, constitutional law, white collar crime. That must be a fascinating area of study. Do you like help people commit white collar crime or help lawyers to?
I try to make sure that my folks can either prosecute or defend if necessary. But the overlap between white collar crime and politics has really gotten a little too close. So we have to do what we have to do. And of course, we also deal with college admission scandals as well in class. So it's good stuff. It's good stuff.
Plenty of those going on. So tonight, students and teachers, we're going to be looking at the judicial branch and the power of judicial review and its impact on the relationship of the national government and states. And we'll probably get into other issues related to judicial review. And I'm going to start off real simply, just because, you know, in some of my prep, and something I've always wondered of, why is Marbury considered a major case? Because to me, the decisions seem to state the obvious. So why is it considered really the granddaddy of all Supreme Court cases for any student or wannabe law student to be aware of? Mr. Chambers, why is it such a big deal?
Sure, it's a big deal because of what we claim it does. That is the notion that the Supreme Court can tell you whether a statute or an action is constitutional is a fairly big deal. Now, that's not to say that nobody understood judicial review. Judicial review, of course, being the Supreme Court telling us whether something is constitutional or not. People understood that, but the idea that the court would come out and say it and then expect people to listen to it was a big deal at the beginning of the Republic. And indeed, what really could have been rough is if folks had said, that's very, very nice that you all think it's unconstitutional. We just don't care. That would have been interesting to see what happened. And arguably, it kind of sort of happened, or the specter of it may have occurred with Andrew Jackson in office. But no one really has challenged the court's supremacy in that area.
Well, if it indeed just reaffirms what everybody already knew, is the significance not in the decision itself, but in Jefferson's reaction to it? Because, yeah, I'll leave it at that.
I think that's right. I think it's right. Now let me be clear about this. Well, I won't say let me be clear, because I'll say let me be clear, and then then I'll say they're gray areas. The idea is everyone knew about the concept of judicial review. That is, people understood the idea that a court would reasonably be a player in deciding constitutional issues. Now, there are folks who also argue that the court should not be the only entity that's involved in dealing with figuring out the constitutionality of matters. And indeed, there's a pretty good argument that says the court isn't the only player. That is, to the extent that the court can only take cases that come to it and can only decide a certain number in a year, there are a lot of things that the president may do that are of dubious constitutionality that the court never talks about, right? So that's sort of a big issue. Now, in fairness, that did go a little ways away from your question. The idea that a president would actually listen is quite important. And I think folks understand or understood that if the president didn't listen, we could be in a tough spot. That did not mean that Jefferson's take was that the Supreme Court was right, just that that was kind of their position and kind of their role, at least a part of their role.
Tim, I'm curious, was, because the larger question students have to deal with is kind of this impact on federalism, but in the constructing of this, of this institution and its implied power of judicial review, were they focusing more on review of Congress or review of state laws, or was there no distinction and they both have an equal place as far as what the framers were looking at that power of review to be used for?
Well, I would start out by saying that both Federalists and Anti-Federalists knew that judicial review would be there. I think students need to be very clear about that. And Brutus, probably the best Anti-Federalist writer on this, acknowledges, as well as many of the other Anti-Federalist writers, judicial review will be there, and they accepted that. What they objected to is what I would suggest is judicial supremacy or judicial sovereignty. So, and Brutus lays this out in several of the late teens essays that he says it's like he's got no problem with review. It's just that they're not, we can't check bad decisions. And there they hearken back to the British policy of being able to hold bad decisions accountable. Which is interesting that the Anti-Federalists use a British example as a way to check the court's judicial sovereignty. So it wasn't review that the Anti-Federalists were opposed to, it was judicial sovereignty. So having said that, to your question was again, David, I got lost.
I'm just wondering, was there any distinction? I mean, were they focusing on review of congressional acts and the separation of powers and checks on congressional power, or were they more?
Well, the Anti-Federalists were most fearful of judicial review of state action, and almost every Anti-Federalist essay that addresses the power of the courts goes there. And they also focus, and Brutus does too, a lot on the word equity cases, because they saw in that phrase in Article 3, equity cases, they saw the opening of just making up stuff, of what we would call now judicial activism. So equity comes up a lot in judicial sovereignty over state courts. They said that it would obliterate state courts.
So is it accurate to say that, because probably the main argument of Brutus in paper, I think number 15, is that this power, this Article 3 power will end up weakening or devouring state courts there?
Yes.
Professor Chambers, in your view, has that played out in history? Was Brutus right?
Well, I mean, first thing is that everybody knows that I'm Hank. Okay, that's number one, right? And I mean, sure, I happen to be a professor, but y'all know this. Y'all know the deal. In terms of devouring state courts, well, no. I mean, again, you run into the idea that there are a lot of decisions that the Supreme Court just doesn't make. So while there is the ability to certainly deem what state courts do as unconstitutional or inconsistent with the Constitution, that doesn't swallow anything necessarily. Now, I think part of what folks have to recognize is that the court has to police the lines, because if the notion is that there's no one there to police the lines, then we might have a real problem, particularly if we deem the document to actually be a legal document. Now, there also is the argument as to whether it's a legal document or not. But if it is a legal document, then presumably a court will tell you what it means. So we can kind of understand how somebody's got to say what this thing actually means. Devouring state courts, no. Devouring state legislation, not really, if you believe the court is being accurate in terms of what it's going to do. because clearly folks are going to step over whatever lines are in the Constitution. And someone has to say, you stepped over the line. Now, the question of supremacy versus review, okay, but presumably if we're going to be a nation of laws, then if somebody or some entity steps over a line, someone tells them you stepped over the line, and then someone says you got to go back to the other side. If you don't do that, then you no longer have a structure, and that really, at the very least, is what the Constitution was supposed to be, a structure regarding power.
Chris, you're probably our expert when it comes to clarifying things for students, and I'm wondering what your understanding of the primary question is. What impact has judicial review had on federalism? What is it that question is asking kids to be able to know and do?
They've got to fast forward to 1868 and then fast forward to 1925. You know, you got to go to the 14th Amendment, then you got to go to Gitlow. Because, I mean, you kind of look at the enforcement clauses in the 13th, 14th, and 15th, right? And then you have to look to see when did, I mean, I have a whole like Rolodex of court cases in my head, but really, one of the things we used to talk about, we used to call the 14th Madison's revenge. In terms of, you know, he wants this national veto over state action. He tries to get it in the body, he doesn't get it. He tries to get it in the amendments, he doesn't get it. So from the grave, you know, we get the 14th Amendment, and eventually we get incorporation. So I think that's really what they're trying to get at in terms of that question, is incorporation. Because at what point do we actually see the Supreme Court coming in and nullifying, if you will, state laws? And it's really not until we get the 14th Amendment ratified in 68. But then again, we don't see it until 1925 with Gitlow. So
do I understand you correctly that you would make the argument that pre-14th Amendment, the judicial branch through the power of judicial review has little impact on federalism?
I would say, yeah.
Doesn't it in essence, doesn't it really articulate what federalism is for us?
How?
You know, in those
in what regard? Give me a context, give me a case.
Well, McCullough versus Maryland.
Okay.
Gibbons versus Ogden. I mean, isn't the court, in fact, its first primary role in many ways, to me, in that, you know, those 4 or whatever period of time is really to provide clarity for the American people of what this federal system is. And isn't that?
I'll jump in here. It largely depends, David, on whether you see McCullough as a case about commerce, or whether you see it as a case about necessary and proper. So I think for students, I mean, it's a good question, but it depends on where you're framing those cases as what's the most important issue. I might suggest it was necessary and proper more so than commerce.
Well, do you agree with Chris that the court plays very little of a role in the, in the impact on the federal system before the 14th Amendment?
I would, yeah. I mean, you've got there was a couple of Marshall cases in the 20s where Cohen, Virginia. So yeah, I mean, there were a smattering, but I think Chris is actually, I think for students to consider, it all changes after incorporation doctrine.
Yeah, but,
really
David, Dave, I'll give you, I mean, the cases you know that you mentioned are good, and Gibbons v. Ogden is a very much an overlooked case, and students should take a look at that. But probably helps clarify. But I would go with Tim, and I would go more back to the necessary and proper clause, and that you know, what does that really mean, which is a huge debate.
Oh, Dartmouth.
Yeah,
Dartmouth is another one of those slap the states around cases.
But if federalism is ultimately about sovereignty and to a certain degree jurisdiction, these cases we're mentioning are really carving out, you know, at least for the 19th century, some clarity on where sovereignty lies, especially when it comes to commerce and trade.
This is why I would push back on that, David. And it's something as simple as the verb is and are, and pre-Civil War and post-Civil War. I'm sorry. I mean,
Thank you, President Clinton.
Well, yeah.
Ow. Ow.
I did not. No, I won't go there.
There are children watching. There are children watching.
Hey, that's another case, kids, you want to look up on your own, and then make sure you get someone to clear your browser history for you. No, but prior to the Civil War, people referred to the United States in the plural. The United States are. It takes a Civil War to say the United States is, and it's post-Civil War because that's the big pissing contest. Really, that's the big contest. You know, you can talk about McCulloch, you can talk about Gibbons. Those are consequential cases, but this is Civil War. This is the big contest, I think.
So I'll push back just a little bit. That is, but we can make the argument that before the Civil War, we simply had a different structure. So that what the court did, if we say it had no effect, what it did was it suggested a structure whereby there wasn't nearly as much for the court to do from a federalism perspective. Because if you had a serious view of the Supremacy Clause and you had a serious view of Article 1, Section 8, then there was a real distinction between what the federal government did and what states did, as well as the federal government not having nearly enough money to really impinge nearly as heavily on the states.
Yeah.
So the court was actually just reflecting what they thought federalism was. Well, once you get the 14th Amendment, federalism really is different. It's just structurally different. And because it's structurally different, now the court says, oh, there's more for us to do. Now, they still didn't do all that much in the first 50 years after, other than mess it up. But once you get into Gitlow, once you get a little deeper, you start to go, oh, the federal government's position is so much stronger vis-a-vis the states and is bringing in so much more money that they are acting on the states a whole lot more. Well, when the court recognizes that and says acting on the states is far more consistent with the 14th Amendment than what went before, they again were just reflecting what the system looked like because the system had changed, which might be me saying, I agree completely with Chris, I agree completely with Tim, and I agree completely with David.
I think there's a,
And that, ladies and gentlemen, is a first.
Let me get in here, Hank, so you can disagree with someone. Let me be the first. No, I think all this is right, but I kind of see it a little bit differently in that in the pre-Civil War period, there's still this political sort of struggle about what's the role of Congress versus the police powers of the states. And the fact that the Supreme Court is allowing police powers to be exercised, even though they're doing something there, it seems to me, by letting that happen. And I see that period, not just, I mean, even after the Civil War amendments, the court begins striking down interpretations like the Civil Rights Act of 1875. And it's a doctrine that is friendly to state power for me until we get to 1937, right? It's when for me, it's when the court kind of says, all right, FDR, you can have your new deal, and we are not going to strike down another law from 1937 to 1995. Anything you do under the Commerce Clause, we're going to allow. I think that to me is the switch from turning, like, allowing the federal government to do more and using judicial review.
I just thought of something. Well, two things, but Tim, all the research I was doing on the Taney slavery cases pre-Dred.
Yeah,
right?
I was going to ask you about Prigg and some of those.
Yeah,
cases.
because now that I think about all those cases, the number of cases that dealt with state laws, especially like in Pennsylvania, and here's the court coming in and said, no, you will enforce the Fugitive Slave Clause. You will enforce these fugitive slave laws. Yes, the Compromise of 1850 with the Stronger Fugitive Slave Act in there, you will enforce these in state laws notwithstanding. So there was some activity on behalf of the court to tell the states, yeah, you may have passed these certain laws that you think you're not going to help these folks, but you're obligated to do this because of what the law is, the federal law. So I had to back up on that one. And the other thing I was thinking of too is I love a great Thurgood Marshall quote about the Constitution did not survive the Civil War. In its place was a new document, the 14th Amendment. So Hank, you mentioned the changing in structures, and I think for students to understand the pivotal nature of that document, changing our structure of government.
Well, Mike, I'm curious because I always think it's good for kids to have an international perspective. In South Africa, does the Constitution Court play a similar role in far as being maybe the key referee between I don't know, do they call them states? Chieftains, I know you've got the tribal areas, but do the constitutional courts play a similar role in South Africa as they do in the United States?
Yeah, I mean, it's different in that in South Africa, there's one court that has the power of judicial review, and that's the Constitutional Court. Whereas in the American system, any court can rule an act unconstitutional, right? But in South Africa, I think I've told this story on a previous broadcast, so I'll just give the broad base of this. The Constitutional Court in South Africa was given the role to determine whether the South African Constitution, as drafted after apartheid, was constitutional. We were talking this weekend, Tim and Chris and I, about these constitutional principles that are just kind of out there that the first Congress was playing around with. In South Africa, there are 34 constitutional principles on paper. And the Constitutional Court was given the responsibility to say whether the new constitution aligned with those principles. And that decision really gave the court a lot of legitimacy in the new South Africa. So yes, it plays a similar role in terms of judicial review as it does in, I would say, maybe even more so than in the United States.
So I read an article from a professor from George Mason University in which he argues that the court is the key institution for the centralization of power in the last 120 years in American constitutional history. Do you guys all agree with that? That more so than Congress, more so than anything else, it's the courts that have played the primary role of centralization of power?
Is that centralization in a branch or at a level, at the federal level or within
a federal versus state?
Okay.
You agree with
that? Well, it's after 1800, so I'll have to bow out.
So again, I'll go back to the concept of what's on the table. The courts don't act on nothing. They tend to act on something. So if we see the 1964 Civil Rights Act, when the court says that's perfectly constitutional, is the court consolidating power, or is the court simply recognizing that the federal government has a right to do certain things? So while functionally the professor may be right, it seems to me that Congress has taken the position that it has plenary authority to do an awful lot. And when the court doesn't stand in its way, it's hard to view the court as being the consolidator, as opposed to Congress saying, every problem we see is a national problem and we need to deal with it nationally. Let's throw it out there and see whether Congress tells us, let's see whether the Supreme Court says it's okay or not. I'm not sure I would view that as the court consolidating power as much as the court saying, okay, looks pretty good to us, or at least it doesn't look like it's unconstitutional to us since 1937 moving forward.
Well, I guess
wasn't that Bickel's advice to Frankfurter? What's the book by Bickel? Least Dangerous Branch might be something that students might want to pick up. But it's not. I think what you're articulating, Hank, is the advice that he gave to Frankfurter as they were wrestling with the Brown decision, I think.
Well, I guess here's my struggle is, I mean, you're absolutely right, Hank, but the court could have, if we want to look through this between or through ideological tinted glasses, from, what is it, from 1937 to 1995, the court does not strike down a single act of Congress. And I got to believe in all of that, especially 1937, that from an ideological point of view, there were a number of times the court could have said, no, Congress, you don't have that power. But the court in the 20th century took on, if I'm reading this guy correctly, is they took on that responsibility, to give Congress more leeway.
Well, but I'd like to pose, I mean, Hank, your statement was, it depends what's on the table. So if rights are on the table, do we answer your question, Dave, a certain way versus commerce power on the table? Do we answer your question differently? So I think Hank's point's well taken, that it depends kind of what the central issue of a case is.
Yeah, but that period, 1937, it involves both powers cases and rights cases, or jurisdictional, if you want to use jurisdictional rather than power, so, I just find it interesting that we go that long, almost 60 years, without the court, saying to Congress, no, you can't do this. And to me, that seems to reaffirm this guy's thesis of, as an institution, and I understand exactly what you're saying, Hank, the court doesn't go out and find things. The court doesn't, it has to come to them, but they could have very well taken a much more restrictive point of view, on those cases, and they chose not to. So was that them trying to assert their position in the separation of powers?
I'd have to go back and look at, sort of do more of a systematic study of what cases or what statutes might have been up for grabs, because part of what you run into is when you think, for example, about, say, the 65 Voting Rights Act, right, or the 64 Civil Rights Act. Well, yeah, I guess you could have deemed those unconstitutional, but there really wasn't a basis to do so, right? I'm not saying that Congress is perfect, but the idea that Congress was just throwing out things that they couldn't possibly have had the power to do, I'm not sure that's the case, right? And indeed, we might well argue that Congress for so long had not done what they had plenty of power to do, that a lot of ways they were playing catch up. So I would have to think about some specific cases where we could have gone the other way, where the court really could have gone the other way with really good arguments and just didn't. The other piece of the puzzle, of course, is it seems to me that the Supreme Court is really at its zenith in terms of power when it tells Congress, you can't do this. Particularly if Congress says necessary and proper and commerce. Particularly in the wake of Wickard versus Filburn, they can do almost anything, arguably, particularly if we're asking, is this an area where Congress can legislate? Because Congress can legislate in almost every area. So I hear what the guy's saying, but in some respects, boy, I don't know. I don't know. I'm not sure that the court is doing anything crazy, and certainly not anything inappropriate by saying, sure, Congress can do that. We might not think it's a great idea, but they have the power to do it. That doesn't strike me as being all that strange.
But to get to the point you brought up earlier, Hank, about Marbury and the importance of that case by just the court kind of saying maybe what was obvious and the politics of it. I mean, it seems to me like you're right. The court can only deal with what is on the table. But then, as you mentioned, it's the ultimate decider of what the rules are. So when it gets the slaughterhouse cases, it pretty much decides for itself that privileges and immunities is no longer going to be something that can be used, right? When it gets Plessy v. Ferguson, it pretty much says, this is our interpretation of the 14th Amendment, And you can't do anything about this until we overturn that, obviously, in Brown, right? So when they get these cases and they make that kind of decision, it can either handcuff Congress, it can either give more autonomy to the states, or it can give Congress more free reign. And I didn't read the article that Dave's referring to, but as the ultimate decider, that is a lot of power to make those decisions, right?
Well, right, but Plessy was a state law case.
Right.
Right. And Brown was a state case. So I hear you, and definitely definitely the Supreme Court has said that there's certain things states couldn't do. Right. So I agree with you that they are the final decider. And part of this sort of gets at an issue that I tend to have a discussion with folks about: is the Constitution a legal document or a political document? And sometimes folks will look at me as though I'm crazy because, hey, I'm a lawyer. I'm supposed to say it's a legal document. Well, in some respects, we could argue, no, it's also a political document. That is, it sets certain guardrails and it says what we want the government to be, but it doesn't necessarily say, and these are the rules forever and ever and ever, amen. That is, we can argue that the Constitution structures a relationship between the people and between the states and between the states and the federal government. And if we argue that it is really a document about relationships, about political relationships, then what we mean by unconstitutional arguably changes, right? So it's what I call big U unconstitutional and small u unconstitutional. Big U unconstitutional means it is unconstitutional and it's against the law. Small u unconstitutional means it is inconsistent with the values underlying the document. And those are two very different things, right? Now, if the court starts to get into saying small u unconstitutional really means big U unconstitutional, then maybe they're overstepping their bounds, which is where we can also start thinking about the political question doctrine and things along those lines. But as long as it says, no, when we say it's unconstitutional, what we're saying is it is clearly unconstitutional with the structure that's been laid out. And as a court, that's what we do. It gets harder to say that they're stepping out of their proper channels. And when the structure says there's certain things that states cannot do, then it seems only reasonable for the court to say, yeah, you can't do that. If Virginia decides we're going to start minting our own money, the answer is no, you're not. You can't do that. Why? Because the Constitution says states can't do that. They can't coin their own money, right? If, on the other hand, the state does something a little different and the court says, that's inconsistent with the Constitution, then maybe if they say it's inconsistent with the principle, but we're going to allow it to happen, okay, that can occur. And I'll give you an example of when they did that. Rucho, the partisan gerrymandering cases. Roberts said up and down, partisan gerrymandering is inconsistent with the Constitution, but it's not unconstitutional.
Okay, boy, I hadn't thought of somewhat. You don't see that as inconsistent. That's your big U, small u analysis. Because when I saw that, it was like, okay, what have you been smoking, Roberts? Thing. Yeah, Tim.
Well, I'd like to ask Hank, would you see Shelby County as one of those cases where, well, because Section 5 for the longest time was, was sacrosanct, and then along comes later when, okay, you don't have to run by your restrictions by us anymore. Does that fit in your paradigm of big U, small u?
Yeah, that one's a little tougher in part because back in 1965, South Carolina challenged Section 5, and the court said, look, you've been a bad state when it comes to voting rights, so we don't want to hear from you. Okay. What made Shelby County so odd was Alabama, and Shelby County in particular, had still been bad actors when it came to voting rights. So arguably Section 5, or really Section 4, Section 4 was still a legitimate ground on which to require that states get permission to use their enacted state laws. What Roberts did in that situation was essentially say, I just disagree with Congress's decision. I disagree with what Congress has said, and it just offends me in general. Now, he was acting inappropriately, it seems to me, because he was second guessing what Congress was doing in a context where the court had already decided Congress has a right to act. In fact, he even said Congress could still pass a new Section 4 if they just did it right. In that vein, that's less, for me, big U, small u unconstitutional than it is the court saying, we just feel like doing this, so we're going to do it. So that's one that I might pull out of that and just say that was just the court going on a tear, and they had 5 votes, so they did it. And other people disagree, but I would not put that in the big U, small u category, even though I arguably disagree with Rucho, although I can live with Rucho. That really is, I think, the big U, small u, where folks are clearly saying it violates the principles underlying the Constitution, but we're just not going to say it's unconstitutional because we just can't.
I'd like to move on to the first sub question because I don't know. I'm thinking we can handle this pretty quickly. And to kind of Tim and Chris first, the whole Constitution, I've never understood, because this is a very consistent discussion within the context of Article 3 and judicial review, this counter-majoritarian notion, but the Constitution is riddled with counter-majoritarianism. So what problem do people have with the court being counter-majoritarian?
What you say? What problem do they have?
Yeah. The whole Constitution's counter-majoritarian.
Well, are we talking about the current U.S. Senate? Oh, sorry, this is a different question. Sorry.
Come on, Chris. Come on.
I mean, it's the usual boilerplate stuff, right? 9 unelected people. They don't answer to anybody. They're on the court for life. They're out of touch with the people. And people don't, I think, it's just a lack of general knowledge among people to understand the stopgap that the court provides. So it is counter-majoritarian, yes.
Right, but the question seems to imply there's some controversy here, and I've never understood the controversy. And I know I'm a simple-minded person, but I'm trying to figure out, why highlight this question?
You are not simple-minded at all. Part of it is, and here's what I would suggest to the students, that they define majoritarian and counter-majoritarian, because they really need to define it. So think about Odysseus tied to the mast. Before he goes and sees what are they? The
sirens.
The sirens, right? We would all vote and say, don't listen to the sirens. We'd all say that. But once you get to the sirens and you hear them call, if we had a new vote, we'd say, oh, we got to go over to the sirens. We got to go over there. When you say counter-majoritarian, what do you mean? The time at which the Constitution was ratified, we leave out who was ratifying it, but if we assume that was a majoritarian moment, that was the time at which we said, these are the rules that we will have in place until we change them. If the court is in fact doing what the Constitution says it's supposed to do, I don't necessarily view that as being counter-majoritarian. I mean, sure, if we had a vote tomorrow, we might have a different rule, but we already in theory had the vote. And when we talk about the consent of the governed in the Declaration, what we're essentially saying is, we all pretty much still agree with the Constitution, right? And so as a consequence, I think if you define majoritarian as being majoritarian as of the time we passed this rule before, then arguably the court, if they're making correct decisions, is being perfectly majoritarian. They're just being majoritarian vis-a-vis a different moment of the majority. And that arguably is exactly what we want to happen. Why? Because we don't want present majorities to overrun what we think is the thing that constitutes us. We tied ourselves to the mast with the Constitution. And if what we've said is the Supreme Court is supposed to make sure that we don't just re-vote because we hear the siren call, then I'm not sure they're being counter-majoritarian in the way that we think they're being counter-majoritarian. I'll step down off the soapbox.
And students, if you can channel this into your statement, what Hank just said, that's money. I'm just going to tell you, 'cause now you just torn apart the context of the question, right?
Well,
which is a beautiful thing.
Which is what I always love to see, right?
Yeah. Well, I think this is a perfect place for a perspective from a political scientist, since you guys deal with subtle, nuanced differences in vocabulary, majoritarianism. What say you, Professor Williams? You on the same page with Hank, or different insights?
No, I think I am. I would recommend that the students read an article by Robert Dahl called "Decision Making in a Democracy: The Supreme Court and National Policymaking." And he wrote this in 1957. And basically, in that article, he defines majoritarianism as whatever Congress decides, right? Whatever bills they pass at a moment, right? Which is problematic, but he's a social scientist. He's trying to define it, just like Hank and Chris were just saying. His argument in 1957 that has been held up in subsequent research is that in most cases, the court is not counter-majoritarian, empirically speaking. It's usually following the national dominant sort of political elite ideas at the moment. And there's a lot of evidence through Dahl, and then later with Rosenberg, who's found the same.
Rosenberg, the hollow hope.
Yep.
The hollow hope.
Now, see, what I find interesting about this question is that Bickel raised this in '62, right? This counter-majoritarian difficulty. And what's interesting for me is that the students think about, how do you respond to that? John Hart Eli came out with a book and said, it's perfect. The court should be there. It should be counter-majoritarian because we should never allow majorities to suppress the rights of minorities. Dahl comes around and says, empirically, it just doesn't happen, so don't worry about it. And then there's another group that says, yeah, it's happening. We've created a juristocracy, and we should be really concerned. And this was largely an argument conservatives made in the 1960s, 70s, and 80s. And now progressives are going to start making the same claims as the court seems like it's ruling against. So I think there's an interesting way to think about just what is this difficulty and how do we respond to it.
I wonder, I would like to go back and then to think about Shelby County in this whole context, because here's a law that Congress had just approved again. So if Congress is a majoritarian body, and we would argue that they certainly have this power to re-up the Voting Rights Act of '65, then would that truly be, would Roberts and his decision, would that be counter-majoritarian?
Yeah.
Yeah, it's a good question. It depends. Well, the problem with Roberts is that Roberts wasn't doing law at that point. Now, and I say that with all due respect, he really wasn't doing law. He was doing policy, and he was doing something. He's never liked the Voting Rights Act. Not since the '82 amendments to the Voting Rights Act, he has not liked it. Now, I'm not saying that he doesn't like voting rights, but he doesn't like the Voting Rights Act and what it's done. because I think he thinks that it deforms politics and political will. Was he going against the majority? Sure, absolutely. To the extent that he was going against the reauthorization of the Voting Rights Act, absolutely he was going against the majority. Does that make him counter-majoritarian? You know, in the sense that he's not doing it right. But remember, step one was the court has to be doing it right. If the court's not doing it right, then they're just not doing it right. I'm not sure we can call them counter-majoritarian or not. They're just doing a lousy job. And on that one, I think he just didn't do a very good job. So I'm not sure I can get into the counter-majoritarian question as much as he was just off on his own, just saying, this is what I like. You know, I like ice cream, and my vision of ice cream is we strike this down. It's like, okay, dude, you got 4 people with you, so, and you've got the black robe, so you win. But I wouldn't treat it as being anything highfalutin. I just think he's what he wanted to do.
Well, you know, on that note, you know, I think about the thousands of hearings that I you know, judged both in classroom and in competitions, and over I get students who would say that one of the primary purposes of the court is to protect the rights of the minority against the tyranny of the majority. And I would call BS. And I would do that on the basis of history, because I'm sorry, you just have a litany of cases, Shelby being one of them, in which that's not what the court's job. What the court's job is to interpret the law. And sometimes the law is not on the side of the rights of majority, whether it's Dred Scott, Plessy, Korematsu. So was I wrong to call BS on that and should go apologize to those thousands of students? Or do you guys agree with me that that's not their primary duty, or one of their primary duties?
Well, if you're going to apologize to previous students, David, it should be about a lot of other things, maybe not that.
That's way down the list.
You beat me to it, Tim. You beat me to it.
Yeah, well, I think I speak for everyone when I say that, David.
Let's ask one of his former students that's sitting on this panel.
That's right. That's right.
Let me throw this out because I do tend to be a structuralist, and that is, I don't think you need to apologize, in part because you're right. They enforce the law. The law is structured in order to make sure that the majority does not treat the minority improperly. That's I think a perfectly legitimate argument, and I certainly think they could have come back to you and said, well, yeah, Mr. Richmond, the fact of the matter is the Constitution is structured so that with respect to amendments 1 through 8, if you do it right, you are protecting the minority against the majority. And if you do the 14th Amendment right, then you are protecting the minority against the majority. So no apologies, and they could have come back and hammered you still.
Anyone else with thoughts on that, or is...
I mean, I would go back to Dahl, and this was in 1957, and he concluded by looking at the cases coming towards the court. He said the court was not effective in protecting, quote, the fundamental conditions of liberty. He says, in the entire history of the court, there is not one case arising under First Amendment in which the court has held federal legislation unconstitutional. And again, I think subsequent, like Rosenberg's argument in The Hollow Hope is not that the court is protecting groups. They're following the legislative and executive branch who decide to do the lawmaking, and then they say it's okay to do it. So they're kind of coming at the back end of it rather than leading the charge.
Another good book on that is Lucas Powell's book on the Warren Court, whether it was functioning within the political milieu of the time. And I think Powell's argument is that is to Mike's point, it's following, not leading.
I just had an in-service this afternoon where the justice on the North Dakota Supreme Court was speaking with us, and kind of interesting. One of the things I wrote down was about people that go to the courts and clamor for justice already have a verdict in mind, right? So they're verdict driven And are they really seeking justice, or do they have a specific verdict in mind? Understanding the court's job is to try and take it where the law leads it, not necessarily with a verdict. I thought that was an interesting way of saying it. So, and for the students, here's a nice quote. And Timmy, I've looked for this and looked for this. I could have sworn it was Madison, so I might just be making this up. But it's like, morality is not a function of arithmetic. So I like that when I'm speaking, when they get the kids to think about the courts, right? What the majority wants is not always right.
That's legit. Let me give one additional, well, two pieces. One is, it's really interesting to think about Dahl in 1957, because obviously it's in the wake of Brown versus Board. 57 is also the first Civil Rights Act that the Congress has passed since the Civil Rights Act of 1875. So really interesting context there. But let me give you another thing for students. Go take a look at Kennedy's decision in Lawrence versus Texas. Because one of the things that's interesting about Lawrence versus Texas is he doesn't talk about rights, he talks about liberty. And essentially says everyone has liberty. And what we're really talking about is when the state can limit that liberty. So that's a slightly different way of talking about rights. That is, a lot of people would say Lawrence versus Texas is about rights. Kennedy would say, no, it's not about rights at all. It's about freedom and what limits the government can place on your freedom. And that's a really interesting way of thinking about the rights versus non-rights issue. So just something for students to think about. And he does a little bit more of that in some of the same-sex marriage cases as well, in terms of talking about liberty, which is really interesting because, of course, we see liberty, the word liberty, in the Constitution, whereas we don't see some other words that we think about. Like, we don't tend to see race terribly much in the Constitution, except in the 15th Amendment, a couple other places. So something to consider.
Can I just add one more thing before we get off this counter-majoritarian? Is that if the students are thinking, okay, there's some evidence out there where maybe the court just empirically is not counter-majoritarian, so we don't have to worry about it that much. I ran across an article today about, obviously how we get justices and federal court judges is through a political process, right? It's the president and the Senate. And the argument was basically that what's happened the last 10 to 20 years is that the Senate has become a body that really represents the political minority because of the way the Senate is composed and because of the filibuster and because of voting rights laws, right, in different states. So their argument is that we might be seeing this court might be a court they describe as minoritarian, and that this is not going to be the court that is going to want to take on some of the reasons how they got there, right? Some of the underlying sort of reasons, because they have benefited from it. And so we might be dealing with a completely different type of court than we have in the past because of the way the politics has kind of changed the last 20 years. So I don't have a lot of details on it. I just wanted to throw out that kind of other aspect here.
Great point. Let me add one more piece about elites, because there is an elites question. Until we got Justice Barrett on the court, all of the then current justices had gone to, I believe, either Harvard or Yale. She came in and she's from Notre Dame, which is elite in a different way. But some of this can just be seen through the eyes of the elites. And the notion, of course, behind elitism and being elite is you don't really think necessarily about majoritarianism. You think about how elites have wanted the system to work. And in fairness, the system was created by elites. There were no non-elite folks at the Constitutional Convention. Let's just be fairly clear about that. And what they were thinking about arguably was not the common man or the common woman at the time. They were thinking about a structure that would allow the country to work well. But I think it's fair to say that their vision of what it would take for the country to work well was what it would take for the country to work well for them. Maybe for everybody too, but certainly for them.
Charles Beard?
Absolutely.
Yay. So the last section of the question the kids had to deal with I looked at for a long time, a little bit confused. I'm all in favor of some major structural changes on the court, possibly term limits. They're expanding the number of justices on the court. But the question asks about limits on judicial review. And in my mind, there already are limits on judicial review. You've got Article 3, Section 2, and the power of Congress to limit the types of cases. You've got the rule of 4, although an informal rule made up by the court, it's still a limit. You've got the amendment process. So I'm wondering from you guys, is there something in your mind as far as limiting the actual power of judicial review? Because I can't think of how you would limit that beyond what's already there.
Well, some folks have suggested a supermajority requirement for deeming statutes unconstitutional. So, 6 out of 9 instead of 5 out of 9. That might be one limitation on judicial review. Other than just flat out saying you can ignore the court, I'm not sure that there's a whole ton once you say the court is the body that should decide what's constitutional and what's not. It's kind of hard to say, yeah, we know you're supposed to decide what's constitutional and what's not, but we're going to limit your power to do so. But anybody else have any ideas?
Well, the exceptions clause, I always had my students look at that. David, you alluded to the exceptions clause.
I would propose.
Go ahead, Chris.
Oh, and then have them play that out, because what does that look like if, you get a group of enough people in Congress to say, okay, the court will not hear any cases on abortion, or the court will not hear any cases on school prayer, or the court. So what does that leave you if you think that's an effective method of limiting the power of the court? It leaves you a patchwork quilt of state courts, or, certainly I don't even know what it would look like at the federal district level. So what would it look like when the Congress steps in and starts controlling the jurisdiction of the court, even though it's there? So, when you allude to that, be careful, because once you take that out in terms of what does that leave you? I think Larry Sabato for UVA, I think he's got some ideas on reforming the court that are pretty solid in terms of increasing the number, and then looking at term limits, and then looking at a rotation, and then looking at every president is able to appoint at least 1 or 2, something like that. I don't know the details of his plan, but it's interesting proposals.
Yeah, you were going to say?
Well, I think if I was, my personal opinion is absolutely no changes, but I would suggest that the students first consider, are they answering the question, what changes would they propose about judicial review, or are they answering in their statements, are they about judicial sovereignty? I think, to Hank's point, the structure is set, and by my lights, it's served us reasonably well. But the issue of judicial sovereignty was a real problem at the founding. And I think for many people today that don't like the court, I think what they're talking about is not review, they're talking about sovereignty. And so so I would urge students to think through those terms, because I think they do matter how you answer the question, are there reforms needed?
Mike?
Yeah, the only thing that came to mind, and this is really, it's kind of a question for Hank and for everyone else, is, in South Africa, they have a court, one court that deals with constitutionality, and everything else is sort of given to other courts. I just don't know if we were to strip other courts of the power of judicial review and say if it's a constitutional matter, it will go to another court, whether that would be a good thing or a bad thing. Would it bring more items to the table, as you said, Hank? And in your estimation, would that be a better thing, rather than letting decisions get overturned at the federal appellate level and just sit there, for years and years?
It's a good question. I am not sure that we could possibly do what we would need to do on those issues, because you'd have to take every federal law and ask, is it constitutional? And we don't like advisory opinions, so we just wait until the cases come up, and that's a rough one. Of course, what we'd also need to do is look into presidential signing statements, right? And that seems like more work than the court's willing to do. And I don't mean that in a negative way. I just mean Congress still, even suppose it do nothing, Congress has passed a lot of laws. So I'm not sure that we could pull that off in a comprehensive way. I'm also not sure that we're used to the concept of courts doing specialized things like that. I mean, we do have specialized courts like drug courts and bankruptcy courts, but I'm not sure that we have any reason to believe that there's a constitutional court that could decide those cases better than your run-of-the-mill Supreme Court. But it's certainly something that's definitely interesting, and I'm not going to say I'd serve on that court, but I might be willing to. You know?
And on that note, students and teachers, we're going to bring this topic to a close. We appreciate your attention and hope that we gave you some insights into the judicial branch. Next session, we're going to be talking about political parties, and we hope that you will join us. For now, peace, love, yogurt, tacos. Bye, 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 bye.